Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. Today in the studio, we have Alfonso Cabanas. Let me tell you a little bit about Alfonso. He is the owner of Cabañas Law Firm, PLLC, works in state courts, handling felony cases throughout the state of Texas, handles federal cases throughout the United States, has represented Mexican politicians, Mexican business people, and other foreign individuals of federal offenses, actually represented a novella TV star in a civil lawsuit here in Texas. I'm going to be interested on that one. Alfonso graduated law school from St. Mary's Law School, University, School of Law, Order of the Barristers, which is huge, National Advocacy Honor Society. So we're talking to a smart guy today. External Advocacy Program. He was a team member, an undefeated school champion, graduated in May of 2006. Oh, you're young. We're going to have some fun today. Got his undergraduate degree from Baylor University, double major economics and international business, was on the Baylor University's Dean's List. Graduated December of 2002, been involved in a lot of organizations, lots of community service, lots of organizations and memberships, president, vice president of all these great places, speaks Italian as well as Spanish, interested in athletics as a CrossFit athlete, soccer coach, involved with outdoor activities. One of the I guess part of your biography that I've been involved in as a sitting district court judge is you are an associate judge or a magistrate judge in Bexar County, working over at the magistration section. So welcome, Alfonso.
Thank you, Judge. Thank you for inviting me. You have no idea how thankful and excited I'm to be here on your podcast. I did tell Alana, who's here with us, that I was a little bit concerned because I know how successful your podcast is. And so my worry was that with this particular episode, I think we might break the internet.
You're off to a good start. You know, this was a situation where I thought to myself, it would be great to get an understanding of what a criminal defense attorney's life looks like, which is why I contacted you. And I thought, who would be good to talk about that on the podcast? I thought about you.
Thank you.
Thank you so much for accepting. I look forward to talking about all the things that relate to your job. Let's get into it. Right. So
yes, sir. Let's do it.
You're a criminal defense attorney.
I am. I started back in 2006 in criminal defense. Mm-hmm. When I talk to law students now, the question is always asked, did you know what you wanted to do in law school? The answer is no. I mean, I in law school, Judge, I think I've told you this before, I did not know, nor did I suspect I was going to be a criminal defense attorney. Mm-hmm. I think it just happened that when I graduated, right, while waiting for job applications to come in, I needed a way to make money. Mm-hmm. And so I'd heard from other, mentors that, hey, go to the courthouse, start getting court appointments, misdemeanors, mm-hmm. and then just do the circuit around the surrounding counties. And that's what started my career as a criminal defense litigator.
You graduated in 06, so I got elected in 08. So you were an attorney a couple of years when I ran for office.
Yeah, and I remember you running for office. I don't know if you recall, back in 06, I was working or helping former County Court of One Judge Alonso.
Yes, absolutely.
And so I was working with him, and I met his wife. And so in all the events that I went with him, I met you a couple of times. Mm-hmm. And that's when I first met you back in 2006, 2008.
He was a good judge. He started and he runs something called the Therapeutic Justice Foundation.
That's right.
Which is involved with specialty courts. I think he started the very first drug court in Bexar County. And as a result of that, he created this foundation after he retired, and he recently gave us a little bit of money, us meaning the felony mental health court. We had a graduation. They supported us by providing some items for the graduation. And so I'm very grateful for that. So you got off to a good start. You had a good mentor there.
The initial meetings, Judge, with Judge Alonso in the drug court were in his house. They were in his house with his wife, Maria Elena.
Yes.
So that's in his dining area.
Yes.
That's where his drug court and therapeutic justice foundation started.
Beautiful. On a shoestring budget.
That's right.
Making it work. Well, so let's talk a little bit about your job. So people have this conception of criminal defense attorneys and what they do. What is it that criminal defense lawyers do that people don't seem to understand? What is it that they don't understand about the kind of job that you have to do?
I think there's a lot of misconceptions, even with current practicing attorneys. But first and foremost, I think what we do as criminal defense litigators or lawyers is our day starts with someone else's worst day. Right? And by that, I mean, I'll get a phone call at 8:30 in the morning, and it's usually somebody's worst day or one of their worst days ever. For example, somebody who got arrested, or family saying, Mr. Cabañas, my son just got arrested. Can you help bond him out? Or Mr. Cabañas, you need it in this court. Where are you?
Yeah.
So our day always starts, with a client in their worst day or deadlines to be met. And so I think that's how my day starts, is, always making sure that I take phone calls from clients because they may be going through one of the worst days in their lives. How
do you brace yourself for that, right? I mean, I get up in the morning, I think about coming to the courthouse, and I'm thinking, I'm a public official. I represent the public. There's an honor. There's an honor and a sense of joy that I feel in being in that particular position. I feel a gratefulness. How do you feel getting up in the morning, bracing yourself, knowing that you're going to be dealing with people that are going to be at a very stressful point, at a very stressful moment, and you're the person that they're looking at to help them?
I think the more you practice, Judge, the more you learn to have empathy for the family members or the clients who call you in those situations. And, what I mean by that is I really believe that us criminal defense lawyers, I think we're the real David's versus Goliath situation.
Right.
I feel like it's not, I don't believe it's civil defense or civil plaintiffs lawyers. I think it's us. Because unfortunately, as much as the Constitution, gives everybody the right, innocent until proven guilty, all these rights that we have to make sure the government hold them accountable, I think a lot of people lose that. And so I think when somebody unfortunately gets accused or charged with an offense, I think all those rights go out the window and people automatically assume that they're guilty.
No, in general, there is this perception when somebody's arrested that they're guilty.
Yes.
And so the reality of it is people generally are perceived as being guilty upon arrest. And as a result of that, the idea of innocent until you're proven guilty is almost like a legal in-court type situation that is a fiction outside the courthouse. In other words, TV cameras aren't going into the courtroom showing, hey, this person is innocent until they're found guilty. There's this idea that if the DA comes back and there's a verdict of not guilty, if the defense attorney does a great job, somebody is found not guilty, maybe there's something wrong with the system, right?
That's right.
And so that's what you're dealing with.
That's right.
Yeah.
That's right. We're dealing with it because I think you hit the nail on the head. Not guilty doesn't mean what people think, right? Not guilty doesn't mean that nothing happened, right? It just means that the government didn't meet its burden.
Right.
And so I think that's a very fine distinction that as defense lawyers, we have to talk to the clients about, help them explain or understand the situation that, hey, not guilty doesn't mean nothing happened. It just means the government didn't meet their burden.
Right. So that's when you talk to the general public.
Yes.
Right. So as you're dealing with your clients, you're showing up to court in the morning each day. They're coming at you stressed. Where have you been, Mr. Cabañas? As you're thinking, okay, I got a lot of cases to go to. I got a lot of courts to deal with. How do you deal with that stress that they feel when you come into the courthouse?
Again, you learn something every day, Judge. I think in the last year and a half, I think I'm pretty, well, not year and a half. What I mean by that is in the last year and a half, I started reading a lot of books about Stoicism, right? And so
I've been doing the same thing.
Knowing about the four virtues, right? And saying, look, I can't control something external. Let me just control what I can.
Right.
And that helps me in understanding, I can't I understand the client's frustrated because I may be showing up 15 minutes late, 45 minutes late, an hour late, 2 hours late.
And it's not really that you're late. What it is you're at the courthouse early, but you got a lot of cases that are set. Your physical capacity can only be at one place at a time.
Right.
You have to explain that to clients.
Yes. Yeah. I mean, every client, and I say this with as much honesty as I can, every client's important, right? And so I share that with them because I want them to understand, hey, I really care about your case. I do have other clients that also want my attention. Just because I'm late to your court doesn't mean that I pay less attention to your case than the other clients.
Right.
And so I understand that they're upset, justifiably, right? Because they're expecting me to be there. But I always listen to them, understand them, and then try to get in their shoes and say, look, I apologize. It's going to be okay. I'm here. Let's work on your family member situation.
Yeah. I always try to do, when I call the dockets in the morning, I only call the defendants' names. I don't expect necessarily for attorneys to be there because I know they got a lot of places to be. And every now and then I'll come across a defendant that gets stressed out. I don't know where my attorney's at. And I tell them, look, your attorney's in the courthouse somewhere. They're running around. You're okay. Everything is okay. They'll be here. They'll take care of your case. And so I have had defendants come before me to tell me that they're angry at their lawyer because their lawyer doesn't ever seem to show up on time. It's a different world, right? Back in the day, probably before I became an attorney, attorneys could charge a certain amount of money. They had fewer clients. They didn't have as many courts. These are modern day times. We're working in an urban area, lots of courts, right? 27 district courts in Bexar County, 15 county courts, and other types of courts like probate courts, et cetera. So you have to be at different places, not counting federal court, not counting outlying counties. We did have attorneys come in today that came in from like Floresville, that came in from Comal County and other counties that they went to first. How do you manage that kind of a caseload? How do you, in order to make a living today, you have to have more cases because there are so many lawyers, there are so many professionals that work in the law. The fees are not what they used to be, I think. That's my opinion. How do you handle that kind of a caseload?
Well, very carefully, Judge. And by that, I mean, I have 2 paralegals at the office. We have a client management software system that we use where it's very specific, right? But in other words, we know how many open cases we have, how many cases are set for plea, how many cases are set for trial. And so we always manage that caseload. And as soon as you click on that screen, it says, Mr. Cabañas, you have X amount of open cases. And I say that because I don't want to put myself in a situation where I'm, have too many clients to handle, where I'm not being the best attorney that they hired me to be. And so I manage that very carefully. Almost every day we check on how many cases we have open, how many cases we close. Because then at the same time, I think, I help out the county through the MAC office by, taking court-appointed cases.
Right.
And the court-appointed cases that I take happen to be, the highest level, first-degree felonies, the murders, second-degree felonies. And so those also require a lot of work. And so I always report to the MAC office the number of cases that I have, and if at any point I have too many, then I'll let them know, hey, put me on pause, let me work on my caseload. But yeah, we have an Excel spreadsheet every month that we check to make sure we don't go above a certain number, so that every client gets the attention that they need from myself and the paralegals. We also have law clerks that come in and help out to make sure that none of the cases fall to the wayside, and everybody gets the attention that they deserve.
Well, back when I was practicing, when I ran, I got my first smartphone. I started running in 2007. And so back then we would document everything. Trish Austin, who's a court coordinator with me now, she's been working for me 25, 26 years now. She came with me from my law office, and we did everything manually with our hand, pieces of paper, thick files. Based on what you're telling me, everything now is sort of computerized. It's app form. You have programs where you manage your case system in that form. And
you're going to laugh at this, Judge, but I still remember going to court, and when talking to the coordinators to reset a case, I would, pull out my planner, right? My paper planner, and look at the dates and say, oh yeah, I'm available, and literally write it by hand or by
at a glance.
Pen.
You can look at a month at a glance.
Yeah, at a glance. I know. The producer's laughing at the same with a bunch of old dudes. But now the smartphone or the iPhone that we have emails, calendar,
Everything.
phones, everything's handled immediately. So if I get a reset on that same day, I check my calendar. If I'm open, I set it for that day. I'm texting back to the office, texting clients. It's a double-edged sword. Why? It's good because it makes us more productive.
Yes.
But at the same time, we literally are available 24/7 to our clients.
Yes.
And I've gotten phone calls on birthdays, not to wish you your birthday, but to say, hey, why haven't you visited my son?
Yes.
Or on vacations or on holidays, and so, yeah, it's a double-edged sword.
Well, it's your own business, right? And one of the things, we used to have a neighbor way back when I was an attorney. We had a neighbor who had his own business, and my wife used to say how fortunate he was because he could set his own hours. How fortunate he was because he could decide when he wanted to work. And I would tell her, I don't know if it quite works that way. When I became a criminal defense attorney, we learned real quick that it does not work that way. Right? I remember every holiday I'm calling people because there's always an emergency during holidays, right? I'm having to talk to clients and say, yes, I know that your son just got arrested. I recognize it's Thanksgiving morning. We'll start working on the process now. And then it turns into like you're saying, a 24/7 type job. So you got to manage that, right? You got to, I know you have a family. How do you manage that type of a caseload, having your own practice like that?
Judge, to quote the words of one of my all-time favorite rappers, Jay-Z, is I tell people, I'm not a businessman. I'm a business, man. We're a business, right?
Yes.
Us, self-employed criminal defense lawyers, we are a business. And so, everybody that I know here at the courthouse that has their own law firm, my fellow criminal defense lawyers, we're all super hardcore workers because, like you said, yeah, we can set our own hours, but if we don't go to work, we don't get paid. We don't see clients.
Right.
We don't collect invoices. We don't submit vouchers. And so we have to be on business, 24/7. Granted, we're not going to work 24/7. We need some time off, to recover, to recharge, to be with family, to de-stress. And so, managing that workload becomes very important because as you get older, right, you have family, your wife, your kids. And so you want to spend some time with them as well and not neglect them. And so balancing that is very important, challenging.
Life balance.
Yeah, very challenging.
Yeah. So how many cases do you generally have a day?
Oh, Judge.
Varies, right?
Trisha's not here because she's going to yell at me. But to give you an example, right? Today you asked me to be here for this podcast, and I showed up late because I was in federal court. But typically in a day, Judge, just in Bexar County, I may have anywhere from 4 to 5 cases. All felony cases. There's times where I'm really, stretched thin. And in addition to the 4 or 5 cases in Bexar County, I may have, 1 or 2 in Comal County, another one in Gillespie County.
And those drives are at least half an hour.
The drives are at least half an hour.
Yeah.
Right.
Yeah.
With GPS, we're able to get the faster routes, but we're stretched thin. And so the day might begin at 8 a.m. in Gillespie and then end here at 1:30 for a 9 o'clock docket, And so, that's what a typical today. That's what today looked like for me.
You do it all yourself? One man shop, one man attorney with staff.
Right. I'm at that point, Judge, and I haven't decided, but I'm at that point where I'm still debating to bring somebody else to help out as an associate. But right now it's myself and then 2 paralegals and a law clerk that helps out with the research.
That's very difficult. But but then you get into other issues there too, right? So I had an attorney that I worked with, sometimes more than one, and people would come in, they would hire me, and then I would say, hey, listen, tomorrow I got 6 cases in court. With your case, it's not substantive. The purpose of this court hearing is basically to get all the information we can from the district attorney's office. So as a result of that, Attorney X is going to go. I'm going to be in the courthouse if you need me, but he's going to show up to court with you to get the notes, because back then we had to handwrite all the notes off the DA's handwritten file or their paper files. And their response would always be, hold on a second. I didn't hire Attorney X. I hired you. You're the person that I hired. You're the person that needs to be there. And so here, the difference with a business as opposed to a business run law firm is that your name is the business.
That's right.
So it's not just the business that's offering services, but it's actually specifically Alfonso Cabanas.
That's right.
So how is that challenging for you?
Judge, you said it perfectly. Exactly. Every client that comes to the office comes to hire Alfonso Cabanas. Right. They don't want to hire person X, person Y, associate Z, associate 1, 2, 3. No, they want to hire Alfonso Cabanas. And even if it's the client's first setting, which is usually an arraignment, which can be waived, right, before court, the client, rightfully so, expects Alfonso Cabanas to be there. No matter how many times I tell them, Mr. and Mrs. So-and-so, I understand it's an arraignment. It's nothing important in the long, in the long run. It's just their initial appearance. They still want the client to be there for their family member because it's important to them. And they feel like, we need to be there because, they hired us to be there. Yes. So again, having that empathy for them and understanding that it may be an arraignment for me, but it means the world to them. Yes.
Even phone calls, right? They'll call and they'll say, "What time is court tomorrow?" And then you could tell your staff member, call them back, tell them court's at 9, and then they'll go, "Hold on a second, why isn't Alfonso calling me?" Right? Do you get that pretty often?
We get that all the time, Judge. We get that all the time. Also, jail visits. The county's done a great job in allowing us to do Zoom visits, which has, made us more productive.
Which is new, right?
Which is new.
We're doing a little bit of that pre-pandemic, but that's really accelerated since the pandemic.
So it's made it helpful for us to visit more than one client. Whereas before it would take us probably 2 hours to visit one client. By the time we parked, got out of the car, registered, waited, walked in, walked out. Now in an hour or 2 hours, we can visit 4 to 5 clients.
Yes.
But even those visits, right? Sometimes, I'll have a paralegal go on a intake phone call with a client and I'll visit another client. But even then, the client still wants to see, the lawyer they hired or the lawyer that got appointed to them. So
where's the lawyer?
Exactly. ¿Dónde está el abogado?
So how do you lay down that foundation? How do you set expectations with clients when they come in to hire you? So what I would tell them is, look, every morning I show up at the courthouse at 8:30. Generally, I'm at the courthouse till about 1, unless I'm in a jury trial or in a hearing. I'm in the courthouse till 1. I'm going to take a lunch. Generally, my lunches are like 1 to 2, 1 to 2:30. And then from like 2:30 on, pretty much every 15 minutes, I'm scheduling a phone call or I'm scheduling a client visit up until like 7 p.m. That's what my days look like when I was practicing. How do they look like for you?
So the first part of the question, right? So when clients come in and they retain me, and again, this was something we've been implementing for a while now, but it's to address that issue, is we give the client almost like a document where I or my staff, where we tell them, hey, this is what we're going to do for you. And so we explain to them that, we may be in court on the day of the arraignment and we may be present in another course, but we'll show up, even if it's late, we'll show up there. We let the client know, hey, we have other clients, but we're not going to neglect your family member's case. And so we break down for them what we're going to do for them. We're going to explain to them that we may be late to court hearings, but we will be there nonetheless. We explain to them that when we don't show up, we have a software that notifies them ahead of time. Hey, be present in court, but you'll get a reset because Mr. Cabañas is in trial. And so we've done that with every client, whether they're retained or court appointed. We'll send them that letter to kind of break down, what they should be expecting from me from the day of hire to the day of, not guilty or dismissal or sentencing. Now, you asked me, I was like, what does a typical day for me look like? It varies. It varies, Judge. Like I said, I always get a phone call from people in their worst situation, family members. And so usually, I'll show up to the courthouse right around 8:30, right? And I'll start making my rounds by that and I'm talking about Bexar County Courthouse.
Yes.
So from the first floor to the fourth floor, if I have things to send to the court or take to the court offices, I'll stop by the back and drop them off. If I don't have the coordinator's text, then I'll stop by and say, hey, I'm running late. I'm going to be in this court.
Yes.
The clients are always notified by my paralegals that I'm running around, going to be late. But yeah, a typical day for me will start off here at 8:30. And right around 1 or 1:30, After that, I'll go to the office. I have lunch at the office, something quick, because like you said, then I have to return phone call. I have an hour or some time slot to return phone calls from clients.
Yes.
And then after that, it's meeting, potential clients. And then the last part of my day is focused on preparing for next day's hearings or upcoming trials.
How do you prepare for that? What is it that you have to do when you prepare for the next day?
So usually, for example, this week, right, we started off January 4. What's today? 7, 6, whatever it is, on Monday. We'll have staff
Time's going by already.
We'll have a staff meeting on Monday in the afternoon.
Yeah.
And we go over the calendar for the whole week.
Yeah.
And so if it's regular, pre-trial conferences, then we'll say, okay, make sure we have the discovery on this guy, that person. If we see that there is a trial announcement date, then we'll make sure that the trial binder is ready on this particular client. We'll check the evidence checklist that the state usually sends us to make sure we have everything. And so we'll do that at the beginning of the week. At the end of the week, we'll go over it again to make sure that nothing fell through and that, we're ready for the following week. And we do that every week just to make sure that we get ready for the following day, that clients are called, family members are up to date, that we have all the discovery, or if we don't, that we know what we need to request from the state so that we make sure we have everything by the time we are set for trial.
I mean, it sounds challenging time-wise, but by the same token, you never know what's going to hit you that day, right?
No.
Every day is different. You can show up. You can never predict exactly how your day is going to go because you're dealing with people. You're dealing with people at tough periods of their life. How do you keep yourself motivated? How do you keep yourself on the game?
What motivates me, Judge, I think is a challenge. Is a challenge in representing my clients and making sure that as a defense lawyer, I hold the state or the government accountable and that my clients' rights are protected at all times. And I say that because what motivates me is, believe it or not, going to trial and getting a favorable result is what motivates me.
Yes.
I see it as a challenge. And that's what motivates me. I take it personal, right?
Yeah.
If I get if I lose or if I get a guilty, I take it personal.
Yes.
And I go back and see what I did wrong to keep it from happening again. But
Now, when you say a favorable result, you're not automatically talking about a dismissal or an acquittal, right? I mean, sometimes somebody could be looking at a 25-year sentence,
right,
and you walk out with a 5-year sentence,
right?
Stuff like that.
Yes.
The wins. You got to look at the wins.
The wins.
You talked earlier about the MAC. Basically, our conversation has given me an understanding that you handle both retained type clients and you handle court-appointed cases. The MAC is something, we talked about the MAC in our very first episode of this podcast with Jim Bethke. It is an organization wherein I applied to the state, obtained a $5 million grant, multi-year, 5-year grant to begin this bureaucratic process. And I hate using that term generally, but it's pretty much what it is. A process that oversees a court-appointed lawyer. So judges now don't have that scrutiny of who are judges appointing. It's that office that does it. We took it out of the hands of the judge for transparency purposes. Who's signing these vouchers? Who's signing the pay that the attorneys get? It's not the judges. It all goes through the manage assigned counsel program. They evaluate them. They look at them. They do all that kind of stuff. They evaluate the quality of work. And so generally speaking, what you're telling me is you do court appointed cases that are at the higher level, first degrees, et cetera, and you get retained cases. What types of cases do you see the most? What kind of cases do you handle more than anything else?
You know what, Judge? It's interesting you talk about how the cases get handled, because the majority of my cases, and I don't know if why this is, or if there's some sort of out there like, oh, Alfonso only does these cases, but I do get from retained clients and court-appointed clients, I do get a lot of the very tough, aggravated sexual assault of children cases, the continuous child sex cases, indecency with child. I do get a lot of those sexual assaults. Those seem to be the majority of the cases that I get through the MAC office.
And I think that could be because very few lawyers, in comparison to other types of cases, are qualified to handle those cases. right? Not every attorney can walk into that MAC office and say, I'm going to apply to be on the list that handles these kinds of cases. You got to have qualifications.
Right.
So not a whole lot of attorneys are on that wheel that handles those kind of cases, from my understanding.
Right.
What type of requirements do you have to handle those kind of cases through the court-appointed wheel?
Judge, for those cases, you got to have a tough stomach. Oh man, tough stomach, because, part of our job as the client's, advocate or defender, again, we have to make sure the state hold them accountable.
Right.
And so on most of those cases involving, child victims, as you know, there are forensic interviews. So we have to go and watch a forensic interview. Sometimes there may be photographs or videos. We have to go watch those photographs or videos. A lot of times there are examinations by SANE nurses. So we have to go see those SANE examinations. And so they're very graphic. They're very detailed. For younger attorneys who are coming up in the wheel, who are looking to get those kinds of cases, I would say you got to get a tough stomach for those cases, because the evidence, the testimony, the police reports, the videos are very graphic. They're very tough. In addition to, you have family members, right, who are upset on both sides, right? The members who are representing the victim, members who are representing the client. And so there's a lot of emotions. And also, these cases have very severe punishments.
Yes.
You're talking about a minimum 25 and a continuous with no parole. You do day for day to 5 to 99. You're talking about Chapter 60, or I don't mean to be technical, but registration as a sex offender, right, for life, or for so you got to have a tough stomach. And know that each one of these cases, and in my opinion, Judge, I think those cases, believe it or not, I enjoy trying them because I've learned a lot. Those cases are very, very difficult because you have to know about, in my opinion, a lot of the Code of Criminal Procedure, right? You have to know rules of evidence.
They're more complicated.
You have to know, hey, man, is the state going to try to introduce this through 3837 or
Right.
3707?
Right. The rules are different for sex cases.
Yeah. And so I'll that's what I would say. If you're looking to get into those cases, have that tough stomach for the evidence, and then make sure you read up on or sit second chair, because they are very technical.
Which means you assist another attorney.
Yeah, you sit second chair. I apologize, Judge.
Yeah, no.
Sit, just say, hey, man, can I sit second chair? Can I watch? Can I learn? Can I ask questions?
Can I take a witness?
That's how I did it.
Absolutely.
That's how I did it. By learning from other lawyers, from some mentors.
That's how I did it at the DA's office. Now, when I came out of the DA's office, I had my own practice. I didn't have, I didn't need to do that because I had enough cases. You're talking about sex cases, because they're very difficult, right? You think of a continuance, you can have a situation where you have some allegation that an adult sexually assaulted, let's say that they penetrated with their finger, a body part of a child. And then they did the same action over a month later. 2 actions, because more than 30 days have passed. Now it's a continuous. That's what you're talking about. Right. Continuous sexual assault. That carries with it a range of punishment starts at 25. If they're found guilty, no parole, right? Is that what you said? Right. All right. So recognizing that, let's say the DA looks at this and says, we have a finger allegation, no DNA, no photographs. It's going to be a word of a child. And her ability to testify in front of a jury versus this defendant who's never been arrested before. It's kind of a risk on our part, right? That's what the DA is thinking. It's a risk. So we're going to make an offer of, let's say, 10 years in prison. It will reduce the continuous. We'll charge him with one act only, 10 years in prison. How do you convince a client who says, listen, I am not guilty. I did not do this, regardless of whether or not they did. That's just what they're telling you. I am not guilty. If I plead to this, I'm going to do prison time. But then you say, hold on a second. If you have a jury trial and a jury trial believes that child, minimum 25, and you're not going to come out on parole like you could if you were to take that 10. How do you explain those kind of things? Like what process do you have to get defendants, to get clients to understand it's always a risk. It's always a roll of the die. And so here you're, looking at things like it's possible you could be found guilty. Maybe you'll get off, who knows? But either way, you have to understand what the situation that you're looking at is, because then you're going to come back and blame the system, me, whoever. Right? If you're doing 50 years in the pen day for day. How do you handle those situations with clients? How do you explain that kind of stuff?
Judge, every time I explain that situation to clients, and I'm smiling not because it's funny, because every time I explain that to clients, and their family members are always present, by the way. But in explaining that to them, the first response from the client's family, not the client, from the client's family is, it's like, Mr. Cabañas, how can you say that? You haven't done anything on this case. and I laugh because, what you see on TV is completely different, right?
Yes.
You see a show, what do the prosecutors always talk about? CSI or something where the case goes from indictment to trial in a month.
Yes.
And so I laugh because the client's family don't realize the amount of work that goes into finally asking for or getting a plea offer from the state.
Mm-hmm.
You're talking about, to keep with the example of the MAC, you're talking about requesting discovery. You're talking about getting a court-appointed investigator.
Yes.
You're talking about reviewing the file with the client. You're talking about reviewing the forensic interview. You're talking about filing trial motions or pre-trial motions. Talking to the
sometimes you got to get experts.
Right, get experts, talking to the prosecutor about, some of the weaknesses in their case, without revealing your cards. And so, but anyways, going back to your questions, by the time that work is done, the client hasn't seen it or the family hasn't seen it. So they think that we're just trying to get their family member to plead, but we're not. So I always tell them, hey, this is what you're facing. And I always get back, well, what have you done? You haven't done anything for my son or daughter.
Yeah.
Well, it is what it is.
Yeah.
But going back to your question, it is a very tough pill to swallow when you're telling somebody, hey, if you take a plea, right, then you may be getting a minimum of 25, right? Or we can reduce it to an aggravated sexual assault of a child, right, which is 5 to 99.
Yes.
You can do 5 years in prison or more. And then, of course, the collateral consequences are, registration as a sex offender.
Yes.
It's very difficult. It's very difficult also when you tell the family members, because after you tell them that, Judge, the next question inevitably is going to be, well, there's no evidence.
Yes.
But when you tell them, ma'am, I'm sorry to say this, but the evidence is the victim or the complaining witness's testimony.
Yes.
Well, that's not evidence. It is evidence, right?
Yes.
Where's the medical evidence? There's no medical records, but that her testimony is evidence.
That's right.
And so it's a tough pill to swallow because they feel like if it's just his word versus her word, the case should be dismissed.
Yes.
So it's one of those where I try to be, careful with my words, explain it very thoroughly, and then try to understand the pain they're going through and explaining it to them and telling them, look, don't feel pressured to take this. Think about it. We'll get you a reset because it's going to be a very difficult situation or choice to make.
Yes. The understanding that testimony is evidence for juries to consider and determine how credible every piece of testimony is that comes in. All right, Alfonso, I'm having a great time with this conversation. With that thought, let's do a quick Q&A break. Don't go anywhere. We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at BeyondTheGavelPodcast.com.
Welcome to the Q&A break. I have Alfonso Cabanas here with me. Let's take a question from one of our listeners. Let's see. Alana just handed this to me. The double magistration is inefficient in Bexar County. How do we get rid of it? Good question with you being on the show, right? Because you're part of the magistration process. They're double magistration. Let me sort of set this up a little bit. In Bexar County, 60% approximately of the arrestees that come from San Antonio Police Department. There are 23 municipalities, so there are 22 other municipalities that make arrests, including other agencies like Bexar County, the Sheriff's Department, constables, let's say that they're school districts, hospital districts, those kind of folks. They all go directly to Bexar County for magistration, but the city of San Antonio takes their folks over to the city magistration. They have their own magistration process set up. They'll say it's not a magistration because they're officially not doing that now, within the last couple of years. They call it a detention hearing, where they make a determination somebody is violated, so it's a probable cause hearing. Somebody's violated the law, there's probable cause, they're going to order them arrested, and then they'll put them on a bus at some point and then take them over to Bexar County so then the magistration can happen. Basically, they're seeing two different types of magistration judges in order to get process through the system. What do you think in terms of inefficient? Why is it that the city of San Antonio magistrates are folks twice in essence, even though they don't necessarily call it a magistration? How do we get rid of that? How do we change that process?
Judge, so let me put some context into that.
Mm-hmm.
So before I became a part-time associate judge in review and discovery, you see these magistration documents.
Mm-hmm.
And so I would see on certain clients magistration documents from, like you were saying, I went to 401 South Frio.
Mm-hmm.
Oh, okay.
Which is the city of San Antonio
The city of San
facility.
Antonio.
Yeah.
And then others would say, no, I went to, Bexar County Jail,
Mm-hmm.
which is where the county has their magistrates.
Mm-hmm.
And then I would have clients come and tell me, oh, Mr. Cabañas, I was locked up for, 23 hours. I said, what the heck, 23 hours, man? Like, and some would say, oh, I was in there in 10, 12 hours. So, that's how I learned or heard about, right, the double magistration process.
Mm-hmm.
I just thought that's the way the city or the county did it. Didn't pay much attention to it. Just when clients would tell me, I would say, wow, man, I didn't know that. That's
Sorry you went through that.
Yeah, I mean, that's unusual. Seems very ineffective, time consuming, cost, obviously. So now as a part-time associate judge, right?
Mm-hmm.
I've seen some with the same thing where San Antonio PD arrest somebody, they take them to 401 South Frio, then they bring them over to the Bexar County Jail where we do another magistrate or the formal magistration, I should say.
So you basically invalidate. Essentially, you invalidate what they did over with the city.
Yes.
Yes.
Right. It's, that's my work with it.
Mm-hmm.
How or when that started, I don't have the slightest idea. Do I think it's...
It started in 2019.
Yeah. Do I think it's efficient? Absolutely not.
Yeah.
I think it's not, you waste a lot of time and resources, that could be put somewhere else. And I'm sure there's a better way. I'm sure that, if ultimately the Bexar County magistrates are the ones that magistrate and set the bonds and the conditions,
Find probable cause, all that.
find probable cause, search warrants, blood draw warrants, then I think the magistrate, the part-time magistrate, or the full-time magistrate should be the only entity magistrating these individuals.
I mean, as a criminal defense attorney, you can see the inefficiencies in a different way
Absolutely.
than a lot of other folks because you're looking at it from the client's perspective. So, I think it's more than just an issue of control. A lot of people used to say, well, the city wants to do this or the county wants to do that. I think it's more than that. I think a lot of it came about as a result of the county opening up their new facility, which we call South Tower.
Right.
And so when they opened up that South Tower, they were expecting the city to come over. But the city then, their response was, hey, listen, y'all didn't really consult us with how this thing was built. And I've met with the chief of police, Bill McManus here in San Antonio. And that one of the things that he told me is, listen, they opened this thing up. They didn't tell us a lot of what was going to be a part of that process. It's inefficient. Police officers are made to wait longer than they should. They're off the street. They shouldn't be off the street that long, that sort of thing. Whereas as a result of that, the county is saying, hey, listen, you're wasting taxpayer dollars. You're however much a year, you're taking time away from defendants. Somebody gets arrested, them having to wait 23 hours before they can go through the magistration process is not reasonable. How do you resolve that? And frankly, I think more than anything, it's got to be the two sides, the city of San Antonio and Bexar County, two different entities, two different governmental political entities coming together, and working that out. like, the county needs to say, city, tell us what it is that is wrong that we need to fix that would encourage you to come over. There's a rent process that's due. The county used to pay the city back when the city had the facilities before 2019, sort of like a rent. That's really the easiest way to say it. They would pay them money to allow them space there to handle these magistrations, because then our county magistrates would go in there and work from 401 South Frio with the city. What needs to be done, I think, is that whole thing that's very convoluted. There's rents involved. There's money that needs to change hands, because of costs. There's facilities that need to be rebuilt. The chief has told me that, I would love to be involved in drawing up how this new process is built up, from a facility standpoint. I think once that's done, I think it would be a benefit. Don't ever want to criticize anybody personally. A criticism that I've heard is that the county, when they built this new magistration process, this facility where everything is going on, they cut some corners, and maybe in cutting some of those corners, it was a deterrent for the city to want to come over. I'm not going to blame either side. I'm not going to say it's anybody's fault, but it's something that needs to be resolved. We could use those taxpayer dollars to do a lot of other things.
Absolutely.
Yes.
Absolutely. I agree.
Yeah. That was a good question. Thank you for asking that. It's very timely. Keep them coming. We appreciate the input here at Beyond the Gavel. Don't stop sending them. Remember that you can text Beyond the Gavel anytime or reach out through our website, beyondthegavelpodcast.com. Now let's head back to the conversation with Alfonso.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back to the show. I'm here with Alfonso Cabanas. Let's get right back where we left off. What other types of misconceptions do clients come to you throughout the life of a case that you sort of have to lay out and re-explain and get them to understand?
Well, clients and family members, right? They always think that we are in cahoots with the state.
Yes.
So, and I say this wearing my hat as a court-appointed attorney, right?
And they always think that the judges are in charge of the prosecutor.
That's right.
That the prosecutors are prosecuting somebody for me.
That's right.
And they always have that misconception.
So, wearing my hat as a court-appointed attorney, I can tell you the misconceptions are when I get court-appointed clients, their family members always think that, the judges pay our fees. So they think that, we're not working for them, we're working for the state. Number one. Number two, when we reset the case for discovery purposes or because we're missing evidence or because there's things that we don't have, they feel like we're dragging it on intentionally to force their family member to take a plea. Right? That's the second misconception. A third misconception is that, and this is the client's misconception, again, as a court-appointed attorney with my hat on, is some of the clients believe that if you drag on the case to trial, they believe that the prosecutor's office is going to sweeten the plea deal.
Sometimes it gets worse. Right?
Yeah. So that's a misconception because, the DA's office here in Bexar County, some of the finest prosecutors in the state of Texas, I'll put them against any other prosecutor's office.
Yes.
But no, that's a huge misconception. The offer does not get better, it gets worse.
Yes.
And so those two misconceptions are what I see day in and day out, as a court-appointed attorney. Now, wearing my hat as a retained attorney, there's not much difference. And believe it or not, the retained clients aren't in contact with us as much as the court-appointed clients.
Yes.
But some of the misconceptions on the retained clients, number one is they don't see the behind-the-scenes work. Right. Like I was talking about earlier, they don't see the discovery process, the file review, the meetings with the experts, the meeting with the investigators, the meetings at the DA's offices. They don't see that. A big misconception, like I talked about earlier, is that they believe that a not guilty means that nothing happened.
Right.
Right. And so when I tell them, look, it just means that the state couldn't prove their case, that's a big misconception for them.
Right.
So those are the ones that I see day in and day out as both a court-appointed attorney and somebody who gets retained to represent clients.
You know, when somebody would come in and hire me and say, I want a jury trial, I'm not guilty, I want to fight this thing, I'll tell them, look, this is how this works. In this particular court, it takes at least a year of time, meaning you're going to go to court once a month for at least a year before your case is sufficiently old enough in comparison to other cases to where it's going to be set for trial. Now, it's going to be set for trial the first month or two subsequent to the first time we go to court, but it's not old enough. There's going to be a lot of other cases that are older. So as a result of that, there's going to be a lot of waiting, right? There's going to be a lot of activity the first couple of months where we're getting all the information, all the discovery, everything related to what the state has to prove. And then at the very end, when the trial date comes around, there's going to be a lot of preparation that's going to be make sure these witnesses are ready, make sure all these other things are going on. But in between, there's going to be a lot of nothing. You're going to show up to court basically to say, I'm ready, let's go to trial. And the judge will say, great. We're going to put you up for trial. However, there's 10 other cases that are older than yours. And we got to take care of those first, especially if somebody's in custody. So a lot of people don't understand that part of the reason why you have to wait is just because there are so many cases that are pending. You talked about the behind the scenes work, that they don't see. One of the experiences, I'll never forget this. I had this as a defense attorney. I would go in to see a judge and I would say, my client, I'm asking for this on behalf of my client. The judge would say, no. I'll say, you sure? Yeah. The answer is no, Ron. Thanks for coming in. No. Okay. I'll go back and tell the client. The judge said no. They would say, how do we know you ever told the judge? How do we know you actually went in there and told the judge anything or asked the judge for anything? So one of the things I do as a judge when people come in, attorneys come in and they say, my client is asking me for you to consider to do blank. I always write it. I take a piece of paper and I write on there, defendant's request for a judge to do blank is denied. Sign it and date it. You come across those kind of issues?
Yes, I do, Judge. And I'm glad you brought that point up because sometimes, and I know you've been a judge for a long time, but for example, I've had potential clients come into the office and one of the first things I should say that they ask us is, do you know the judge?
Mm-hmm. Yes.
Do you know the judge? And so when I ask them, well, I mean, yeah, I know the judge. I mean, I know all the judges because I work in Bexar County. But but do you really know the judge? Like, can you, do this or do that? I said, oh, well, you're talking about that. No, I'm sorry. Like, that's
right.
We don't do that here.
Right.
Because, some of the clients will come in. Well, another misconception is that, for whatever reason, if you know the judge, you're going to get a better outcome. I said, no, that's not how it works.
Right.
I can't just file a motion and say, judge, please sign this. It's not going to happen.
Right. That's always the thing, right? They don't recognize that plea offers, that the prosecution comes from the DA's office.
Right.
And that's a huge office. Totally irrelevant who the judge is as it relates to plea offers. Unless, judges have a certain proclivity to be tougher on DWIs, then maybe you'll see that prosecutor and that court be a little tougher in their offers because of the judge's proclivity. But as it relates to their independent individual case, there's nothing that a judge can do to help them.
That's right.
Really. And that's a good point. That's a very, very good point. You talked about the work that you do and looking at forensics, looking at interviews from law enforcement, all those kinds of things. Technology now is different. Technology requires defense attorneys and prosecutors to look at voluminous amounts of information compared to what they used to. What's that process like? If you're a one-man attorney office, what does that look like? How are you able to review? Because you've had jury trials with me in front of me, and you've done a great job in those trials. And sometimes those trials have involved looking at a lot of video. I'm thinking of one in particular where it was a video intensive case where you had a lot of video to look at. How do you do that as a one attorney person?
Well, Judge, and I think in the last 2 years, right? In the last 2 years,
mm-hmm.
In my case in particular,
mm-hmm.
I've really welcomed and implemented in my office the use of AI
mm-hmm.
and discovery, video review, and reviewing files. And it's cut down our file review system, I think, almost 3 times. Mm-hmm. What we used to make is more productive and efficient. Again, the MAC office has sends out these emails with information on vendors that offer, AI video review mm-hmm. or AI file review. And so these things are great. Without that email, without the Mac office sending that email, I would not have known about the software that I use at the office to review these videos. But for example, Judge, I'm telling you, I still do review videos, even though we have an AI software. I still sit down on trial cases and review the videos, as lengthy as they may be. But for example, sometimes when you're looking at a murder case that has tons of body worn camera or tons of dash cam videos, you're talking about 9-10 hours of actual me sitting down reviewing these videos, because there could be inconsistencies that could help us in case. This AI generated software reviews these videos, and in a matter of 20, 30 minutes, you have a video review that will give you almost a caption of the time in which you can do a search or a query to say, hey, give me the times in which my client confessed, or the time my client was Mirandized, or hey, look for these inconsistencies. And so that AI software helps us go through these videos much faster than me just sitting down watching these for hours.
That's interesting.
Yeah.
Yeah. That's not something that I was familiar with. And I know law enforcement is doing something similar as they review evidence. So you talked about speaking to clients when they come in. Family members are always present. One of the complaints that I hear is that a defense attorney is not returning a phone call to somebody's aunt or to a defendant's sibling or something. And the reality of it is, and one of the things, anytime I'm out in the community and they'll go, hey, there's a lawyer, and I tell them, hey, we can't talk about cases. They'll say, no, I just want to tell you, this attorney is not returning my call. And what can I do about it? And I ask them, are you the defendant? They'll say no. So, well, the attorney doesn't have an obligation to return your call, right? Well, how does that work with you and in your office?
The same thing, Judge. It's before, again, when I started as a younger lawyer, younger lawyer, you make the mistake of, clients, family members call.
You want to make them happy.
You want to make them happy,
yeah,
and give information, and that gets you in trouble. Right. So for a while now, we've instituted it again in that documents that we have clients sign, whether they're retained or court appointed. We ask them to list, hey, who is your point of contact? List the person, and they know that if you list, for example, Jane Doe, then that is the only person whose phone call we're going to take and to whom we're going to give information. So in case somebody else calls, we'll say, look, you're not the point of contact. We can't give you information. Right. And of course, they'll call me all sorts of things other than my given name. But yeah, it's just, that's what we do now, because otherwise you get bombarded with phone calls from, grandma, grandpa, aunt, uncle, girlfriend 1, girlfriend 2, wife 1, wife 3.
Yes.
And that just becomes one big mess.
Well, and then because of the attorney-client privilege that the defendants have, you have to get that kind of stuff very explicit.
Yes.
You got to tell me specifically who I can tell to and what can I tell that person. Right. And so beyond that, they don't, you owe the duty to a client to keep whatever information you have to yourself.
And they get upset, like you said. They get upset. Well, why aren't you telling me he's my son? I said, ma'am, I understand, but you're not the point of contact. I mean, if you want him to add you, just, visit him or have him call us and we'll gladly add you. But I just can't divulge because of attorney-client privilege. I can't tell you anything about his case. If you want to know court setting, go on the Bexar County website, look up, that person's name, and you'll see the future court settings.
As a criminal defense attorney, I'm sure you're always asked questions. You're out in the public. Somebody says, you're a lawyer. Let me ask you some questions, right? What are some of the most common mistakes that you see that people make after they're arrested?
Oh, man. I mean, do we have time? Like, how long is this show?
So common is a lot of, yes.
A lot.
Yes.
And a big part of that, Judge, is, again, the misconception that, well, if I tell law enforcement what happened, then they're going to release my son or daughter, right? Or if I tell the officer, hey, this is the deal, they're going to release him, or they're going to, take him off the handcuffs. So again, the biggest mistake they make is once people get arrested, they start talking to the officers, giving them, unsolicited information. They start giving too much information. They start, by the way, pointing fingers and making law enforcement's case a lot easier because they're just talking nonstop. So that's the biggest mistake they make, is right away they start. Well, that, and number two, right, is, don't fight with law enforcement. That's not going to take you anywhere. Don't get combative. Don't raise your voice. Like, try to stay calm. You're going to end up picking up a charge if you're, getting in their faces or pushing them or shoving them. So just once you're handcuffed, they're not going to get released. So just be calm, be patient, let them go through, call me, and then, we'll see what we can do to bond them out or get them out of that situation. But yeah, I mean, fighting with law enforcement, giving them unsolicited information, essentially you're giving up your rights.
Right.
The right to remain silent, the right to not incriminate yourself. You're giving that up immediately.
Yeah, police officers are human.
That's right.
Yeah. Should someone ever talk to the police without a lawyer? Is that something that you would ever think would be a benefit?
Judge, I've done this for almost 20 years, and I've always advised my clients to never talk to law enforcement without a lawyer present. Even, obviously not if they're a suspect, but even if they get that initial phone call, hey, just come to SAPD or BCSO headquarters and we're just going to have a friendly talk, you're under arrest. No, even if you're innocent, you're just wanting a witness, no, never go talk to them without an attorney present.
I mean, even if you say, this is my name and look, I was there, but that did not happen. You've already admitted who you are, which is an element of the state's case.
Right.
You've already admitted that you were present at the scene, which is an advantage to the state. So yeah, even just by giving the preliminary information,
right,
you're helping the state.
Absolutely.
Yeah, that's a good point. Have you seen any types of cases emerging lately? More in the sense of, like, lately I've seen more of this type of a case. Lately I've seen more of that. Have you seen anything like that?
Judge, I don't know if I was sharing this with you or someone else, but over the holidays, when I was working my shifts as a part-time associate judge, I did see a lot of domestic violence cases, a huge number. But a lot of the defendants or the accused were women. And so over Thanksgiving, over Christmas, I saw a lot of, females assaulting their partners, their spouses, their husbands, their boyfriends. Whether it's the stress from the holidays or the stress from the Christmas shopping, who knows? But during my time, I did see a huge number of women being accused of, assault, bodily injury on their spouses.
That's a stressor. And in the last podcast episode, I spoke to William Cruz Shaw, who is a district judge handling juvenile cases, and he mentioned that they're also starting to see more females getting arrested. Is that a trend? I told him on the adult side, generally 72% or so nationwide of arrests are male. Is that something that is starting to shift a little bit, starting to change?
Judge, I don't have the numbers, but I can tell you just from observation, the last times that I've been, working as an associate judge, I have magistrated a lot more women than I have men. Particularly, like I said, and between Thanksgiving, Christmas, and New Year, the shifts that I worked, there was a lot of women who were defendants for assault cases on their spouses. Wow. Again, stressors of the holidays, who knows? Right. But I did see a large number of women getting arrested.
Well, let's talk about your work as an associate judge. So you mentioned, and we talked about at the beginning of this podcast episode, that you are an associate judge. How did you get that position? What does that look like for you? Is there a conflict? Is there some sort of issue with you working as an associate judge on behalf of the criminal district judges and representing criminal defendants in front of those same judges?
Right. So I've been working as an associate judge, I believe, since March or April of 2025. There was an opening in the Berry County system. And so I was notified about it. I submitted my application. I went through the round of interviews with, several district court judges. I think it was one or two or three. And I was fortunate enough to be selected. I've been selected, to be a Berry County part-time magistrate judge. And by part-time, I mean, our shifts are weekends. So the part-time magistrates will work starting Friday, 11 p.m. to 7 a.m. And we'll do, Saturday and Sunday. The last part-time magistrate shift ends Monday at 7 a.m. And so we'll do that on a rotating basis. throughout each month.
So in Bexar County, we have 3 full-time magistrates. They're full county employees. They're associate judges. And so they work shifts. One person, our presiding judge, has a shift during the day, Monday through Friday, 8 hours. And then afternoon, the second shift of 8 hours is a second magistrate or associate judge. And then the night falls, or the overnight shift falls to the third full-time associate judge. So then we have 14 associate judges, part-time associates like you, that come in and handle the other shifts. So that tells me that you probably do a lot of weekends. You do a lot of holidays.
Yes.
Yeah. You do overnight work?
Yes, I do overnight work. I believe during the holidays, Judge, I had 2 overnight shifts, and overnight is starting at 11 p.m. and ending at 7 a.m. So I had 2 of those shifts over the holidays, over the Christmas break.
What does that work look like for you?
You know, Judge, it's been very interesting work. You know, in my 20 years in representing, again, people who are detained, who go through law enforcement, who are behind bars, seeing again the back, right? Like how
When they come in? Yeah.
it's an eye opener in many ways, because you see what they're going through. And personally, again, I've learned to, you know, have more sympathy, right? Or empathize with them a lot more, because it's a lengthy process, right? From the time they come in, they get arrested, they see different people, and they're going through the process. They get these wristbands as they're going through, and some of them have no clue what's going on. Some of them don't know what's going on. They just know they're behind bars. They're waiting to see a judge, or waiting to see the PR person to get a PR bond, or waiting to get their blood drawn. They have no clue what's going on. And so it's, you know, by the time they come to me, they've been in there for a long time. And so it's eye-opening, because it's made me realize that it's tough for them. It's tough for their family, because they're almost like in limbo, right? They're in this unknown. They're in this, you know, upside down, right? Like Stranger Things. They're in this upside down where they don't know what's going on. And then by the time they see me, it's starting to click as to what they're being charged with, what the bond amount's going to be, what pretrial release conditions they're going to have. So yeah, it's eye-opening, because now, you know, to answer your question, by the time they come to us, they're frustrated.
Right.
They're impatient. They're like, why is this taking so long? Why am I being charged like this? Why is my bond so high? Why are my conditions so restrictive?
Right.
And so now, as a lawyer, I say, now I know what you're going through, man. So you know, let me explain it more carefully, because now I do know your situation.
So you sort of became educated on what their experience was.
Absolutely.
Yes.
Absolutely.
So what happens if somebody comes to hire you? Let's say they got arrested last week, looking for a lawyer. They came to you, and you're going through the process, and you realize, I was the individual that magistrated you. What happens then?
Just, I think in that situation, I've had one conflict like that. And it happened to be a client that was arrested when I was working. And so I let the clerks know. And so they took that person off my docket so that somebody else could magistrate that person. But I only had one conflict like that. But in general, if that ever happens again, yeah, I mean, without a doubt, I would definitely withdraw myself, or not, you know.
You can't handle that
No,
case.
I wouldn't handle it.
Yeah. So is that something that happens very frequently, you think? Or?
It's only happened to me once. It hasn't happened at all. I haven't, and usually you'll know, because by that, you know, if somebody comes in, more than likely I won't recognize the name.
Right.
But when you see the magistration paperwork, you see the judge's signature at the bottom, and my signature is so illegible that I know it's mine. And so, yeah, that's how you're able to recognize. I would recognize, you know, if that's somebody who I magistrated.
That makes sense. So, you enjoy that work? You like it? You like going in their graveyards and doing that kind of stuff? Dog watch?
It's definitely, you know, talking right as a defense lawyer, and making sure that the people who are accused know they have rights.
Right.
I use that, judge, to let them know, hey man, you know, like, the process is slow, right? It's not as fast as you want it to go. And my job, and I told them this, judge, I tell them my job and these officers' jobs is to get you out of here as quickly as possible so you can be with your family. And I remind them, judge, that, hey, you're innocent until proven guilty, right? You're innocent until proven guilty. I go, please understand that. This is just part of the process. It's slow, it's time consuming, it doesn't go fast, it's pretty boring, but we're trying to get you out of here as quickly as possible. I go, but I need you to make sure that you know your rights, that you understand them, and that, we get you a reasonable bond and some conditions, and, get you to your families.
Very important work. So you have, let's say, a client comes in, or a prospective client comes in. They want to talk about a case. You tell them, obviously, right? Defendants have certain rights. One of the rights they have is to decide whether or not they're going to go to jury trial or not. That's up to them, right? All you can do is advise them. You give them your thoughts, your opinions, your expertise. How do you evaluate whether a case is something that you should make an attempt to work out versus you should make an attempt to say, hey, this is a triable case. Let's go to trial on this. I mean, sometimes defendants come in, back when I was practicing, and they would say, I want to fight this case. And then they give you the facts from their perspective. And then they ask you, what do you think? And you say, those are the facts from your perspective. Obviously we haven't seen what the state has. Generally, it's not very similar sometimes. That's right. So, how do you make those kind of evaluations? This is a triable case.
And I really say this, Judge, as honestly as I can, right? Because I told my clients the same thing. When people ask me, oh, how do you do this, man? And you're representing, guilty clients. I say, hey, man, like, remember, everybody's innocent until proven guilty.
Right.
So, client that comes in to retain me, or a client that I get appointed to, I hold that presumption of innocence to the, full force.
Yes.
Right. So every client is innocent until the state, meets their burden.
Yes.
And so I say that because every client's going to come in, I give them that presumption of innocence. And so they're going to say, yeah, man, I want to go to trial because I didn't do this. All right. As the evidence comes in, just like you said, law enforcement has their evidence, their side of the story. Our client has their side of the story. And the truth is always somewhere in between.
Always.
And so in deciding whether to try a case, plenty of things, I take into account. If it's a misdemeanor case, obviously the consequences are not that severe. Most of the time, the clients will be happy with a probation offer just to get the case over with. On the felony case, as you move up the felony levels, right, the consequences get more severe. So on a first degree felony case where it's 5 to 99, where we're talking about a continuous sexual assault of a child case, right? If the evidence is just so that the client wants to exercise his right to jury trial because they are innocent until proven guilty, then we'll look at the fact, or we'll look at the evidence, and we'll say, look, here are the pros and here are the cons, your choice. Keep in mind that if we lose, this happens, and if we win, this happens. But I let them decide. When I was younger in practice, Judge, I would make the mistake of telling them what to do. But of course, that always comes back to bite you, right? Because the judges always say during the plea, did anybody force you? Did anybody tell you? Oh, Mr. Cabañas said, well, So, that mistake doesn't get made anymore. But we're very careful that last meeting before we decide to go to trial or not. We always look at the evidence fully and give them the pros and the cons. And ultimately, it's their word. I said, look, man, I'm ready either way, right? I believe in your innocence. You're innocent until proven guilty. It's just a matter of whether you want to risk it, roll the dice, or take something that's more certain, like a plea.
Have you had any experiences? Has there ever been a case that has shaped, maybe affected the way you view the justice system, good or bad? Right. You had an experience and you thought, I see the system differently now as a result of that case, or as a result of the experience in this case. It's a tough question, right?
Yeah. And I'm trying to think, Judge, because I guess let me tell you why. And I'm talking about this particular case.
Yes.
We were talking earlier about, I know this is kind of boring. Your producer's like, what a bunch of boring guys. But
I don't think so.
Believe it or not, I do read a lot of books on stoicism. There's a book, and I'm drawing a blank, but there's a book that I've been reading on the criminal justice system and false confessions. There's a book that I read titled Biased, which is a fabulous book.
Interesting title.
Yeah.
Yeah.
And so, and I read those, Judge, and I say this because this particular case that I'm talking about went to trial here in Bexar County in 2025. My client, I was a court appointed attorney, and I was the gentleman's third court appointed attorney. The other two court appointed attorneys and my client and the client had, they just couldn't get along. So, they parted ways. So I took the case on, and the judge at that time said, "Hey, Mr. Cabañas, you're coming in, but this case is getting old, so we're going to have to go to trial pretty soon." And it was a very voluminous evidence-wise case because it was a sexual assault of an elderly, right? So it was a pretty serious case. The client had been in custody for over a year, I think, year and a half. The client met with the guy, adamant that he was innocent, he didn't do it. So looking at the evidence and seeing, hey man, this case is a lot of holes, and I'm talking from the very it seems biased, but the very my defense attorney biased perspective that there's a lot of holes in this case. Number one, and then number two, again, in my opinion as a defense lawyer, I think law enforcement and their investigation jumped to a conclusion, a wrongful conclusion, that my client had committed this offense because they missed all these holes in the investigation as far as things that weren't done, or jumping to conclusions, or not following up on leads, or not doing things that that we brought up during trial. And so nonetheless, we went to trial. This case also had a civil component to it, right? And so the complaining witness had also sued, through her civil lawyer, sued the apartment complex where she resided. And so, anyways, that particular case changed the way I viewed the biases that we all have, whether it's defense lawyers, judges, law enforcement.
Yes.
Because I think that's when I first saw, I was like, hey man, I think law enforcement went in with a very clear bias that my client was guilty, that he did it, that there was no other way around it, because they never gave him that presumption of innocence. I think that case, needless to say, it was a very good outcome. He got not guilty. But yeah, that particular case was one where, in fact, some of the detectives and I during cross-examination were literally, shouting at each other because they got so confrontational in my questioning and their answers, because I was pointing out things that they hadn't done correctly, or pointing out their biases in their investigation. But that's one that really opened up my eyes to some of the biases that I believe law enforcement has in their investigation.
So the idea that they went into an investigation looking for ways that they could prove their bias, as opposed to taking in information, good or bad, whether it helped them or not. Here, they're looking for things to help them.
That's correct, Judge. Yeah. That's correct. And that's something that I tell clients all the time. Going back to your earlier question, do I tell my clients to talk to law enforcement without a lawyer? The answer is no. Have a lawyer present.
Right.
Because I believe that by the time law enforcement gets involved, I think that they have these blinders on, and they think that the client or the suspect is guilty. And they're going to try to find ways to justify that bias they have. And so, yeah.
There's this perception that sometimes people want to seek an attorney that is experienced, is great, but they always want a pro bono lawyer, right? You always get asked that question, right? I'm at a political event. Somebody comes up and says, "Hey, there's a friend of mine that's looking for a lawyer. You recommend anybody who's great who does cases pro bono?" That's a very common. I'm sure you get asked that question a lot. How do you respond to something like that?
You know what, Judge? That question comes from your pro bono or family members who always want free advice, or want a discount on the fees.
The best clients, your family members.
No, those are the worst clients. Those are the worst clients. I mean, at the end of the day, what I tell clients is this: look, man, this is your life. This is your freedom, right? This is your freedom. I don't think you should be, nickeling and diming your freedom.
Right.
At the end of the day, do you want to go to prison or not? you should make that choice. Look, it's an investment. It's an investment in the attorney who's going to help you deal through the situation, who's going to walk you through, who's going to talk you through, who's going to show you the evidence, sit with your family, and help you guide you along. Look at it as an investment. It's not money thrown away. This is your freedom we're talking about. Just like you always want to make sure you have the best doctor.
Right.
You didn't go to the pro bono doctor. You go to the lawyer who's got the experience and, who's going to get you out of the situation.
Yeah, somebody who's going to represent you.
Exactly.
Yeah. Well, Alfonso, I've really enjoyed this conversation. Are there any last thoughts, any final words of wisdom that you have for our listeners?
Final words of wisdom. Judge, I'm going to take this opportunity to address something that, I've talked to a lot of colleagues about it, and I think it's very important. In my practice, I've had some great mentors. Two of my mentors, right? We have, you might remember Doug Daniel.
Yes.
He recently retired.
He
Great
did.
guy. Miss him a lot. Hope he's having fun in his ranch. And his former law partner, Brandon Hudson, also a great friend of mine that I worked with some awesome cases. But those two guys, great mentors of mine. If you recall, Brandon, unfortunately, died, and I think we're coming up on the 5th year anniversary. But I say that, Judge, because, in talking to colleagues, I think most criminal defense lawyers, we don't talk about mental health issues enough. We're so overworked with our clients, with our practice.
It's an isolated practice.
And so I think it should be something that we defense lawyers talk about more, have issues with, and I say that, talking about Brandon very respectfully is, I was one of his closest friends and I didn't realize that he was going through some very severe, issues in his life. So anyways, for whoever's listening, defense lawyers, talk about it. If you need somebody to, approach, come talk to me, talk to your family members. Because it's one of those things that, we need to talk about. Our job is very stressful. It's very isolated. Like you said, we have nobody, to either stress about it or talk to them about it, but definitely something that I think in our practice should be addressed more, talked about more because of the number of cases, the stress of these cases.
But you're dealing with other people's problems.
And the pressure we put on ourselves in handling situations. So, I feel it's something that we should address more, talk about more. And the criminal defense bar should, do something a little bit about it.
That's a great point. You gave me a great idea for a future podcast episode. Thank you for that. You really, the work is demanding. It's stressful. I think, generally speaking, it doesn't pay the way people assume that it would pay. You got to do it because you love the work.
Right.
But you always have to take those mental health breaks. That's something that I've recently come to think about and analyze over the last year, how important it is to take care of yourself. And regardless of what you do, you mentioned the Stoics and Stoicism and reading that type of stuff. It's very important to learn those life tenets as to what you can and cannot do to shape your life and to focus on yourself in terms of being happy,
right.
Taking care of people that you love, that sort of thing. That's important. And so, I think a big part of joy that comes from being a mentorship, because you talked about the mentors that you have. Obviously, these two individuals found something that was important. I know you do the same. I've seen you mentor folks in the courtroom. It is important to take care of others. And so as a result of that, I think it's important to just be happy. Right. Be happy. I'm excited. I didn't timestamp this episode at the beginning. It's January 7th, 2026 at this particular point in time. The listeners over the last year have probably heard me say too many times, I'm 57 years old. I'm no longer 57. I'm now 58 years old. So I'm a year older. I'm getting ready to start my classes at UTSA. And what we're talking about now, your point, your last words of wisdom, I think is something that I need to address with my students as well, right? Talk about coming into the classroom, make sure that it's a sanctuary for them, a safe place, a place where they can express ideas and learn about and from each other. And that's what lawyers do. That's what lawyers do every day, is they learn about themselves, they learn about others, and they try to carry that wisdom to help other people have a better life.
Right.
Interesting. Good point.
Thank you.
Thank you for being here with us today.
Thank you for the invite, Judge. I look forward, hopefully, to getting invited again on another topic.
Oh, you could be a returning guest.
I hope so.
Yeah. Well, you give me a topic and we'll definitely talk about it.
Thank you, Judge.
Appreciate you having you. We've reached the end of today's episode. Big thanks to Alfonso Cabanas for joining us and to you, the listener, for tuning in. Be sure to subscribe, drop us a question, and keep the conversation going between the episodes. You can reach out by sending your questions and thoughts anytime through our website or by texting the show in the description box. Thanks for listening. We'll see you in a few weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.